Now the chair lays out House Bill 20 by Representative Cain. The chair offers a committee substitute and recognizes Representative Cain to explain his bill and the substitute. Good morning.
Good morning, members. Good morning, Chair. In 2017, Justice Kennedy in Packingham versus North Carolina, the Supreme Court case for 2017, an opinion joined by several courts we may call more liberal justices, referred to social media as the modern public square. They acknowledged that these few dominant websites, for many, are the principal sources for knowing current events, checking ads for employment, speaking, and listening. He called them perhaps the most powerful mechanisms available to a private citizen to make his or her voice heard. On April 5th of this year, in the case of Knight Institute versus Trump, Justice Clarence Thomas, in concurrence, chimed in that he believed that technology platforms like Twitter may properly be regulated as common carriers, like the phone system, or places of public accommodation, like a retail store or movie theater. In his concurrence, Justice Thomas suggested that common carriage regulation for social media platforms might be appropriate, given the historical unprecedented concentrated control of so much speech in the hands of a few parties. On the other spectrum, none may call Elizabeth Warren a conservative. You might say something otherwise. She's criticized Facebook as having too much power for removing her political ads when she was running for president. At this point, a small handful of social media sites drive the national narrative and have massive influence over the progress and development of medicine, science, social justice movements, election outcomes, and public thought. House Bill 20, in a way we could say, has three parts. The first demands some transparency out of the social media platforms. To bring transparency, this bill requires a social media platform to publicly disclose on an accessible website how the platform selects the content users see and what sorts of content they allow. It also requires a social media platform to implement an easily accessible complaint procedure for users to submit a complaint regarding illegal content or the platform's allegedly wrongful removal of content. The bill would also require the platform to investigate any report of illegal content within 48 hours of receipt of that complaint, Saturdays and Sundays excluded, to allow the user to know why it was removed and receive feedback and a review of that removal decision. The bill would also include legislative findings that the biggest social media sites, those at least in the bill we're saying at 50 million active users in the United States, are acting as common carriers of public speech. It then draws a critical distinction between censoring based on content versus censoring based on viewpoint. We can all agree that these sites need to moderate content like violent or overtly sexual posts. However, they cannot deny you participation based on your viewpoint, including your political preferences or religion. The second part of that bill allows people who have been censored to get back online. Under this bill, social media site with over 50 million monthly users in the United States is prohibited from censoring a person or the content that person posts based on the person's viewpoint or on the viewpoint expressed in the post. If the site does block or restrict a user based on their viewpoint, that user could file suit against the site to get back online and make the site pay their attorney's fees. Alternatively, the Attorney General's office can bring suit on behalf of a user or a group of users. The third part, which is actually in the middle of the bill, that'd be sections 3 to 5 of the bill, ensures that non-commercial email messages are not blocked erroneously by email service providers. This would ensure that constitutionally protected speech, like political or religious messages, are not blocked for using certain political buzzwords. To close, though, I'd say it's important to note that speech censorship doesn't just harm conservatives. Our model of government relies on good faith exchange of ideas, in which much of the public conversation is muted. Both sides suffer. As we've seen, it's occurred to people of all political viewpoints. I'm concerned that if this trend continues, we will end up with a conservative internet or a liberal internet, and Americans on each will only ever hear from like-minded voices. Maybe you've seen that movie during the pandemic. What was that called? The Social. Anybody know what I'm talking about? Yeah, the Social Network. Was that what it's called? I don't know. I'm not listening anymore, Clardy. You're tricking me. This Social Dilemma on Netflix. It was around the time that you might have been learning about Tiger King and other things. You might have watched the Social Dilemma and seeing how we're all only seeing certain content that I believe it can be injurious over time because we're not hearing both sides of the story. The committee substitute makes changes to the disclosure requirements. It goes from a quarterly to biannual report and provides for more time for social media companies to respond to user complaints. Went from 24 to 40 hours. And also, there's a provision that it's 14 days we accepted Saturdays and Sundays as well. Ensure that maybe they don't need to hire people on those weekends. These changes were made after having conversations with industry stakeholders. And with that, I thank you for your time. Request the opportunity to close.
Thank you, Representative Cain, and thank you for working with many other stakeholders on this issue. Members, any questions for the bill author? Representative Busey.
Thank you, Mr. Chairman. Representative, just got a few questions for you. One, what's your inspiration behind this bill? Why'd you bring this bill before us today?
Yeah, well, I actually had this bill or a similar bill drafted in 2017, and kind of timing is an important one. There didn't really seem to be an appetite among the body for the legislation. We saw it again in 2019, still didn't really see an appetite, but I think that people are interested in it, and that also so that you'll find this this is the subject of the call of the governor for this special session.
So in 2017, what was your inspiration behind this bill? I'm just trying to figure out the problem we're solving here.
Is that a sincere question?
Yeah. I want to know why, when we have multiple avenues for social media, you can choose what company you want to participate with. Why are we trying
Yeah, I don't think there's that many multiple avenues, and I think that I have a witness here, Scott McCullough, will be able to better explain those concerns. I believe, as you'll find, especially after hearing from witness, I think it'll better help answer that question. But I think they are acting as a common carrier. I think ensuring that they are able to block certain content that is allowed under Section 230. That'd be, I think, 47 U.S.C. Section 230. That's the Communications Decency Act of the federal government that allows them to do content restrictions. But viewpoint is a problem, and it shouldn't be had. Do you think people should discriminate based on people's viewpoint?
Let me ask you this. How'd you come up with the 50 million threshold?
It's a good question. Well, it was kind of shot in the air. We were trying to find something that's significantly large enough, and after talking to a lot of people, we were advised to that number, and maybe they could answer it better. But this bill and a similar bill out of Florida was enjoined. And so when we were looking at how to craft something that would be constitutional, people that are much smarter than I, we went to them and asked, hey, how could you regulate this in a manner that would withstand constitutional scrutiny? And they arrived at that number.
So you had this idea in 2017. Someone in Florida had this idea too, and they kind of took your idea. Did they see your bill, or are they similar? Are y'all working on the same agenda here?
I've never talked to the author of the Florida bill, but it's a movement across the country that people, I believe, and my voters are concerned about the power that these companies have.
Your voters are concerned about it?
Yeah.
Not your constituents, but your voters?
Mr. Busey, thank you for showing up today, sir. I've been here for, gosh, almost, I don't know how long, this is the middle of the second special session. You've had plenty of opportunity to come and talk to me. I've been on the floor every day.
I appreciate you thanking me for being here. I wanted to come here to work today, but it doesn't seem like you're answering my questions.
I believe you're not engaging in sincere discourse, sir.
You won't explain the 50 million threshold. Why you picked a number out of the air.
Yeah, I told you that it's from
what organizations are caught up in this 50 million threshold? What organizations are we going to restrict their individual freedoms? What businesses are we going after?
So YouTube has 126 million users in the United States. I guess that would catch up YouTube. TikTok has 91.9 million users in the United States as of last year. Twitter in 2020 would have 41.5 million users in the U.S.
So Twitter's not in this?
No, I think they're here. Let's see. Oh, Twitch users. That's Twitch. I apologize. So Twitch apparently isn't there. Instagram, of course, is already Facebook. Pinterest is at 66.8 million. Reddit's at least in 2019. I'm not sure so if they're there right now. They're at 47.87 million in 2019. Google, YouTube would be classified in this.
What's not classified? I'm just trying to understand.
Anybody under 50 million, sir?
There are companies under 50 million out there.
Probably. There's probably plenty of social media companies that none of us are aware of.
Under their guidelines to participate with. I'm just wondering why we're picking and choosing businesses to attack in Texas.
It has to do with when they get up to a certain size that there's really not competition, that I believe that they become akin to a common carrier.
There's no competition. You just mentioned multiple businesses that I could choose to participate with or not participate with, so is that not competition?
I don't think you actually can. I mean, for example, what's the name of that company? Parler, they got shut down. I mean, I have an iPhone, so I'd have to switch users to be able to use it, so there's really not any kind of true alternatives outside of Twitter and Facebook due to their size.
Is Facebook necessary for you to participate on it? It's a choice, right? You don't have to have a Facebook account.
Yeah, well, it's a choice whether you move product by freight. It's a choice whether you use a telephone, but through the common law, we've decided to treat those as a form of common carriers due to their size.
Those, not these. That's the difference. Talk to me about what the definition of common carrier is.
A common carrier is a private entity that that moves freight or goods for hire, and it's open to the public writ large, and with certain exceptions, being maybe dangerous goods. And for example, here we have exceptions for lewd and lascivious behavior.
You just said for hire, right? Mm-hmm. What fee do you pay to be on Facebook?
Well, there are businesses that do pay fees and buy certain advertisements. For example,
that's a choice.
You just heard
I'm saying you as a user, what do you pay to be on Facebook?
Well, there are companies that are paying them to be on it, and that's why I said they're akin. No one's saying that. That's literally the word. They are akin.
I'm talking about Texan Briscoe Cain. You have a Facebook account. I think we're even Facebook friends. Mm-hmm. What do you pay to be on Facebook?
I pay to advertise, but again, the word,
I'm talking about to have the account, because this is saying
Representative
these are
Busey, the
common
term
carriers.
in the Section 1 of the bill says it's akin to, and I'm saying it's akin to. I did not say it.
So you're redefining what a common carrier is here.
No, sir. I'm saying it's akin to. It is like one. The difference being that one's not paying to be on the platform.
So here, common carrier definition has a fee. These don't have fees, but you want to just say.
I'm saying they're akin to common carriers, and I think you would disagree with that. The distinction.
I strongly disagree with that.
Well, the distinction you were making is why I didn't say they are common carriers. I said they're akin to.
Under your bill, talk to us about some content that will be changed. Tell me what a user experience on Facebook or Twitter, your choice, would be like after your bill becomes law.
I don't think it'd be much different than today, except that if someone's content is restricted, they're informed of exactly why, and they're given an opportunity, a legitimate opportunity to appeal that decision.
What kind of content are we talking about that they could appeal?
Anything that is blocked or censored or.
So Holocaust denial could be blocked?
The Holocaust denial absolutely could be blocked. I think so. Under Section 230, and this is where we're balancing a thin line of what the federal government has not fully preempted, and it says in total that no provider shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. I would say that discussing the Holocaust like that would be constitutionally protected, but still, I think it would probably fall under Section 230C2A of the Communications Decency Act, and they'd be able to take it down.
And how do we get an answer to that? We're just going to have a bunch of lawsuits, and we're going to go challenge this and spend taxpayer dollars on this?
I don't think you'd be spending taxpayer dollars on it. If the Attorney General takes it, there's attorney's fees, and that's why it's set up for a private citizen to take, and the courts would be deciding that. And the courts are paid for with fees and court costs.
Let me ask you this. You picked a 50 million threshold for the United States. This is a Texas law, Texas bill. Why are we using a U.S. threshold? Just curious. Your inspiration.
We may have a witness who can better answer that one.
Well, you've had this bill since
I was relying on
in mind.
I was relying on experts to come up with that number, and that's how they thought it best fit.
Let me
Draft the bill.
I don't think I'm getting through. The business of Texas, I've been told forever, is business. And then I wake up this morning, I come into work, and we're having a bill that is a war, an attack on business in Texas, and I'm just trying to understand why we would do that in this body. Why are we doing that in this Capitol? Why are we attacking business from the government of Texas? I'm just trying to understand. You've been working on this since 2017, but I'm not hearing inspiration behind it.
We're working on something, and saying that I had a bill drafted in 17 is I would say, slightly different than that, sir. You would ask where it had come from, and I was letting you know it's been something in my mind for a long time. How to get at that? With this session, we talked to people, and they thought 50 million was a proper threshold.
Let me ask you this. Have you had any personal experience with this?
Absolutely.
Tell me about it.
Well, me and my buddy Beto O'Rourke got in a little spat. Sometime in 2019, when he discussed, hell yeah, we'll take your AR-15s and AK-47s, I had a little tweet at him. I believe it was something like, "My AR is ready for you, Robert Francis." It would be the exact quote. And so it was unable to use Twitter, I believe, for 190 days.
So that you were suspended from Twitter?
Uh-huh.
And you disagree with that action?
Of course. Yeah, sure.
When you make a threat on someone's life with a gun and Twitter's private business decides to suspend you, you disagree with that action?
Well, I think that would be a question of whether or not, if 230, if court thought something was excessively violent, then they would have their full right to do so.
So let's take your case. You got suspended. Under your law, walk me through what happens now.
Under my law, I would be able to do nothing because the effective date of this is 91 days after this special session.
So you don't want to explain how this would impact that situation?
I wouldn't be able to do anything about it right now. This happening.
Let's say you say something like that again after this bill is in effect. Mm-hmm. Tell me what would happen.
Well, you would, one, be told the exact reason for it. So they would either tell you that this violated our community guidelines because the exact reason, and then you'd be given the opportunity to appeal it. And they'd have to then tell you what was going on, whether or not your appeal worked. And if that was illegitimate, I assume you'd have a cause of action.
And so then you would appeal it, you'd go to the Attorney General, there'd be a lawsuit?
No, you
right?
could bring your own private lawsuit. You wouldn't need the Attorney General.
You could choose.
The Attorney General would choose whether or not they take a case, just like they do any other case.
And you would take this to them? How does this work? I just want everyone to
The
understand.
Attorney General can do it on their own accord, and I assume someone could, request that, but you would do it on your own. It's a private lawsuit. You can hire your own lawyer.
You referenced the Florida bill. What's the status of that bill right now?
The Florida bill is under a preliminary injunction, and due to that, we went to, again, I guess people that understand some of this a little better than I do, and asked them how we could draft something that did not have the issues that the Florida bill did. Some of those issues being, it specifically prohibited banning candidates from their platform. So it was treating politicians differently than, I guess, regular citizens. It also had an exception for Disney, which is a little odd, so it's not treating everybody equally. I think there are a few other issues in the bill, and so we asked, hey, what was wrong with that? How can we do ours differently? For example, our bill prohibits viewpoint discrimination. The Florida bill did no such thing. So the content aspect of our bill is in line with Section 230. That'd be 47 U.S.C. 230 of the Communications Decency Act. Those things that I've read off of what I think Senator Hughes calls this parade of horribles, those lists of lewd and lascivious and violent behavior, those are content and not viewpoint. And so they can certainly go onto content, but viewpoint would be a fact question, and I don't believe that these social media companies should be arbiters of truth.
Good point. Let me ask you this. Do you believe that social media platforms are private companies?
Yes.
Okay. So why are we going to regulate a private company around the freedom of speech issue?
Mm-hmm. Due to the size,
Because they're big.
Due to their size, believe they're akin to common carriers. In law, we regulate private companies all the
Let me ask
time.
you this.
We've decided that they can't discriminate on
They're big.
certain basis of things.
So are we going to, what's next? We're going to regulate what people can walk into a Walmart and scream and say and attack and say things to their other customers? Are we going to regulate Walmart saying, well, this person says something racist to another client, but you can't remove them anymore?
I don't
we
think
can have an
it would be
appeals process
appropriate.
on that.
I'm not thinking they
big,
would be
too.
at that point
They
less
serve a lot of
akin to
individuals.
a common carrier.
They're private business,
They're slightly less akin to a common carrier than a social media company is.
slightly less akin, even
Yeah, I
though
don't-
neither one of these meet the standard of a common carrier.
Well, and again, that's why the word is saying they're akin to a common carrier. And as you've noticed, I read off a few.
The distinction is
members of
important,
The
though.
U.S. Supreme
Being
Court
akin doesn't
believing that
make
they're
it
akin to common
the
carriers.
same. I understand your point that it is used by a lot of people, but one, there's not a cost. Two, what is the line you're willing to cross with regulating private business, is my question, because this crosses a significant line. The next, we tell the private small business owner of a restaurant what he can and can't allow people to say in his restaurant. Can they wear a shirt? Can they come in without shoes? Can they yell at a customer and say something because it's their freedom of speech, even though they're in a private business?
Busey-
Because that's what we're doing here.
Mr. Busey, do you support the eviction moratorium by the federal government that tells private businesses?
This
they can't
is a
evict people?
private business bill, and you are telling Facebook and Twitter and all these other social media companies that they can no longer regulate their business the way they want to.
That's not
You're
how
taking
we're
away their ability
them
to
we're-
have the speech that they want to have.
Well, we're giving them guidelines of how they can do it, and I believe we're doing it properly within the context of federal law.
You know, it's frustrating that we would show up today for the purpose of having a war on business, taking away people's freedom of speech, taking away their rights, and then just doing it in a sense that we can't even talk about our inspiration, but we see copycat bills all over the state tied to the big lie, which we have another bill on today. And it's just incredibly frustrating that this is how we're using tax dollar monies. Thank you, Mr. Chairman.
Thanks. I'm glad you mentioned it. Again, I'll remind you that I had requested a draft of such a bill in 17, long before maybe any election issues that you alluded to.
Yet you won't talk about your inspiration for it in 2017. Thank you, Mr. Chairman.
You're welcome, and certainly very encouraged to hear that you and Representative Cain are Facebook friends. That's the kind of spirit of bipartisanship and civility we like to see in this committee. Members, any further questions for the bill author before we get into public test? Yes, Representative Johnson.
Thank you. Thank you, Chairman Cain. Wanted to visit with you and on a couple of things. On page 2, and later again in the bill, it talks about an element of resides in the state. What is the purpose of that line, page 2, line 33?
You said page 2 what? Oh, a person that
Line
resides in the
33.
state?
Yes, sir.
Well, we're giving people that reside in the state a cause of action, so the user would need to reside in the state.
Is there a potential, if unintended, that you are creating a concept to try to avoid interstate commerce and federal regulation?
I'm not familiar that wasn't a thought in my mind.
Because I noticed this session, you were also part of a piece of legislation that created silencers, gun silencers.
Yeah, I co-authored a bill, which a lot of us do, okay?
And it had similar language that required only inside the state action. And I believe we had a discussion that that may be an attempt to try to avoid some form of federal regulation. And so are you again attempting here to create some kind of a carve-out?
I think I answered your question. I believe this has to do with the cause of action. The person would need to reside in the state.
Okay. Have you ever prosecuted a human trafficking case?
No, but I bet you're going to tell us about how you used to be a prosecutor.
Thank you. I appreciate that very much, Chairman Cain. And my concern is, in those cases of prosecutions, oftentimes federal penalties are greater. And so you may have a case where the federal prosecutors want to pick up that offense, and the use of the internet is always considered interstate commerce for purposes of jurisdiction. Are you worried that your attempt to change that definition could impact federal attorney generals from having the ability to prosecute some of the worst human traffickers in our state?
I have not, thought of any of that. I'm sure maybe you can talk to some others.
Okay. If that was
never heard of that
potentially
question.
an unintended consequence to your definition of internet activity, which would contradict existing tools for federal prosecution of human traffickers, would you agree that maybe we need to reconsider your analysis?
If some, scholars come forward showing that is a definite consequence, not some theoretical, I'm sure we could look at writing some proper language, but that was not an issue that was raised during the regular session with a similar bill or the last special session. It's a novel one that no one has discussed before. Of course, I was open to it. This does speak towards, the bill does speak, if you're aware, if you've seen, the bill does speak towards sex trafficking and prostitution and preventing that and allowing them to censor that kind of content.
I am, and that's probably in response to FOSTA and SESTA, right?
The response to what?
FOSTA and SESTA?
I don't understand what you're saying, Austin.
FOSTA and SESTA, which are the acronyms for the federal legislation to allow for internet companies to take out instances of human trafficking and sexual exploitation for
Okay.
proper liability. I'm sure you're aware of those provisions in looking at this, and that's why I'm glad that my personal experience can help engage in this debate, and I'm asking if you would consider that your definition may conflict with legitimate prosecution purposes with regard to the federal government. Would you be open to considering whether or not your attempt to limit in the state on an internet definition maybe needs to be corrected?
I'm open to all kind of legitimate discourse
Okay,
regarding
great.
those things. Yeah, of course.
So we can continue to talk about that at another time.
Yes, ma'am.
I appreciate it very much.
Of course.
On that 50 million users, you keep saying that there are going to be other people that will talk about that. You've talked about them as experts. Could you tell us who those folks are that are going to testify today, since you were not able to elaborate on it, so we can ask them?
Well, let's be cautious there. Regretfully, I wasn't able to get as many witnesses as I would have liked finding out about these things on a Friday. And of course, maybe I wasn't able to have as much discussion with my colleagues as I would have liked last special session or this one so far, where we haven't been able to maybe talk about these things. And so I do believe we have one today, Scott McCullough, and others that can.
Wait, what was the name? Scott what?
I believe Scott McCullough would be your better expert on that.
Okay.
I haven't seen the list, and it was kind of difficult to do a last-minute thing to get people here the way they were able to in the previous regular session or during the special session in the Senate. They had.
And Representative Johnson, members, just so you're all aware, we do have, and certainly we all have access to this, but if you look at our current registration, we do have a number of industry representatives representing probably different sides of the industry that are signed up and registered to testify this morning. Okay. And I doubt Representative Cain has been able to see all of the registrations, but they're available. And one of excuse me, and one of them is the gentleman that the bill author is referring to.
Okay, great. Would you do me a favor? If any of those other folks that you relied on for expertise in this 50 million determination shows up to testify, would you give us a heads up so we know that's the right person to ask questions?
Sure. I just, I think you can imagine the difficulty of trying to get people here with that.
No, I'm not suggesting that. I'm just saying, I know when Representative Busey asked you questions about your inspiration for 50 million, you said that you talked with folks.
Yeah.
And you relied on experts.
Yes.
And you deflected the question respectfully by saying that there was somebody else that was better to testify.
Yeah.
And I just want to make
But as far as the 50 million, there would be some people that are out of the state. These are kind of experts on what I believe on this, these bills and these concepts of how to do them properly. That helped us arrive at that number.
And if they show up today,
I don't think they're going to show up today, but I can certainly try and connect you with them at some later date. Be happy to.
if you see anybody here, just let me know. I really appreciate it. When you look at your 50 million, is it possible that you're basically targeting 9 companies?
However many companies fit into that number.
So like Facebook, Instagram, YouTube, Twitter, TikTok, Snapchat, LinkedIn, Twitch.
However many fit into it. If you fit that, it's going to continue to grow, shrink, and expand.
And there are ways for you to create laws where you bracket your impact. For example, we've seen over this session where you've created laws and bracketed it by population so that your intent targets like urban communities versus rural communities. And in
The
this
intent
case,
for the size has to do with my belief that they're akin to a common carrier, and thus they're at a certain size.
so your suggestion that the reason for 50 million is to create the concept of a common carrier because they have a significant amount of users.
Yeah, the size of their market share. Mhm.
And they do not transport people or goods or services, right?
They transport information.
Is Amazon a common carrier?
Under this bill, Amazon's not part of the bill.
I know they're not part of the bill, but just logically so people understand what you're saying, when you talk about 50 million and suggesting that that is your purpose, which is to create a common carrier,
Yeah, certain freight
usually
companies can be akin to common carriers.
they can be akin, and often it's the concept of a monopoly, right?
This came from the concepts of antitrust breakup of the railroads.
And monopolies, but I don't think Amazon is a common carrier, and I think we'd all probably acknowledge and recognize that Amazon has really done very well in that particular market. Are you suggesting that if you get so big that government needs to step in and modify your business practices when you're a successful business?
No, but at a certain size, you become akin to a common carrier, and I think under this instance, the state has a legitimate state interest in protecting the fundamental rights of Texans.
Have you looked at and are you aware of whether or not you believe that these top 9 companies, in your view or other people's views, tend to lean to more of a liberal setting?
Some may say that, but the purpose of this bill is to protect speech of all, and that we all benefit from being able to have public discourse of varying degrees. And thus, as you may have seen, depending on the content of the post, let's say Facebook or Twitter or something, they might put something at the bottom of it saying, hey, this is disputed content, or fact checkers have said something, or here's the alternative view. And this bill doesn't touch that at all, where in fact Florida told them exactly how they could do it. We completely left that alone and allowed the company to decide how they can do that. So while there might be an issue of some kind of maybe fact dispute, it still allows that company to say that they disagree with that concept.
So let's talk about some of these smaller companies that you are not targeting. MySpace, Parler, Gab, and Parler is one that common thought is that Parler is a more conservative site, correct?
Okay.
Would you agree? Or
I think that was the intent by the creators, yeah.
okay.
And I think
Gab,
half of our concern is that if we continue down this track, we're going to have social media sites for one viewpoint and another viewpoint. I think that's dangerous to our free society.
and it's almost fair to say Fox News is one viewpoint and MSNBC seems to be another, right?
Yeah, I think you could say that, yes, ma'am.
So what if we said on Laura Ingram's show, by God, you have got to show 30 minutes of Rachel Maddow when you stop talking, and vice versa. Is that where we're going to go next? Is that what you want?
No, I don't think so. I don't think that's where we're headed. I don't think they're as powerful as kind of your large ones. There are room for market entry, but as we've seen, again, you mentioned Parler, there's really not room for market entry when a cell phone provider such as Apple says you can no longer download their platforms.
And
there really is no true competition.
so, however, it seems like actually the analysis to you is that you're creating a carve-out and you say, well, we can't commit a crime, right?
You can't. I don't understand.
When you talk about, tell me what your definition is, content versus viewpoint discrimination.
Okay. I'd say content's what would be contained in that expression. Just maybe foul language would be content that the platform can exclude. And again,
Foul language is one that can be excluded?
Sure, and I would draw you to Section 230 C2A of the Decency Act, and I'll read it to you again. And this is content, by the way. No provider shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. Those are content restrictions.
Okay.
The bill, you'll find in the bill, we refer to that in a way. It's on page 12. You'll find that in kind of in two places, section 143A.005, saying this chapter does not subject a social media platform to damages or other legal remedies to the extent the social media platform is protected from those remedies under federal law. That's the liability shield under 230. You'll see it again at line 24. The social media platform is specifically authorized to censor by federal law, and that's a a reference to that provision that I just read you. On the other hand, viewpoint is the purpose behind that post. So I'd say, in other words, content restrictions are speech restrictions on certain subject matters, while viewpoint singles out a particular opinion or perspective on a subject matter for treatment different from that of other viewpoints.
And so, for example, in content, when it talks about the fact, and as you say here, you can't require them to allow publication of materials that would violate laws, such as on page 14, or line 14 of 12, as you cite, preventing sexual exploitation of children. And again, that's probably in response to FOSTA and SESTA. And so you can't commit a crime. And so if Parler was found to have been promoting and helping incite an attack on Capitol police officers, which led to law enforcement's death, then obviously you would agree that somebody could step in and say in our platform, we don't have to allow a medium or avenue
Yeah, I think
for
that would,
violent
I think that would
activity.
fall under Section 230.
Okay. So let me get back to your 50 million. In this circumstance, wouldn't I, as a business, then just cap my users at 49,999.99 and avoid your law?
I guess someone could do that.
Let's talk on page 3. You require that these entities and private companies provide the following information. The platform shall, and as you know, and I'm sure your intent, it means they must do so, correct?
I think it must.
Publicly disclose accurate information regarding its content management, business practices, and then skip down to line 16, other algorithms or procedures that they've developed.
Okay.
And so you're requiring that a private company publicly disclose their trade secrets.
No, in fact, if you go up to line 3 on page 3, section 120.003, construction of chapter, this chapter may not be construed to limit or expand intellectual property law. So intellectual property law still applies.
Okay.
If intellectual property law says that disclosing blank would infringe on their, would, allow them to disclose a trademark, then that's not what it's asking.
So
to
then,
do.
if disclosing an algorithm, no doubt, was in violation of intellectual property law, why are you putting it in here?
Because I think you're reading it incorrectly. So it's asking you to explain with specific information the manner of doing that. And so in a hypothetical, you could say, and by the way, this is what's really important is subsection B, the purpose of A.
Subsection what is so important?
Subsection B,
Okay,
that's lines 20 to 22.
Okay.
That is the purpose of subsection A. Okay, so the subsection B, the disclosure required by A must be sufficient to enable a user to make an informed choice regarding the purchase of or use of access to or service from that platform. This allows, one, some kind of accountability to know whether or not they're engaging or they're following the proper guidelines for content restrictions under Section 230. It allows us to know whether or not they're engaging in viewpoint discrimination. For a business, for example, it allows them to know maybe how they're being treated, whether they're being treated unfairly, or to actually know the rules by which to play. They need to know if there's certain words that are preventing them maybe from engaging in their audience or preventing them from purchasing a certain ad or wording a certain ad so that they can know how to best use that platform. And I think in light of that, so the example could say,
and so
we have an algorithm based off of search criteria that shows potential customers your information because of how often you post. It's not asking you to reveal how your algorithm is made or the specifics behind it, but you could explain to people what it does.
And so you're requiring this private business as part of their structure and corporate establishment to comply with your obligation to provide information for a service that you're not actually paying for. It's free,
Okay.
right? And in most of the times,
Yeah.
just as we've seen, as you have demonstrated, if you don't like corporate activity, you boycott. Like the
do you mean to
Chick-fil-A
say, though,
debate
don't
that you
think the-
engaged in last time.
You don't think that the means by which we use social media, such as the lines in the ground, the way it's broadcasted, and the way that it comes to our phones was fully privately funded, or that the government assisted in that, and that we then have some kind of reason to tell them how they could maybe use those things?
So then, can you tell us your distinction on which social media platforms have been given government funding so we know how to apply it to all of those folks? Because I think we're, again, trying to get back to, why are you picking 50 million users?
Due to their
If your
size.
analysis is, I think these people are providing a space where they've gotten government assistance, then why is that not your determining factor? And who gets restricted, who doesn't get restricted?
And no,
Compliant
everybody's
with your
been,
rule.
in a way, benefited, just like roads being built by the government. Everybody, regardless of their size, has benefited from the creation of the means of electronic communication traveling through our lines.
And while those roads are government and publicly benefited, I can't choose to drive 150 miles an hour on them, right?
I mean, you could. You just might get in trouble for it.
I would get in trouble.
Yeah.
Correct. And so there are, in everyday life, legitimate restrictions. And if I go on Facebook because I want to interact with my cousin and see how her kids are doing, Facebook has a responsibility, or Twitter, that if somebody posts a pornographic photo, that I don't have to be subjected
Twitter
to
can
that,
absolutely
right?
take it down, 100%.
Okay.
They're authorized to do that already in federal law, and we clarify they're authorized to do that here.
And what if somebody wants to spout a bunch of misinformation, or wants to spout a bunch of information about Holocaust deniers
I think
or
that-
anti-Semitism?
I think that would depend on the thing. I think, one, if it ranges into what's considered harassing under Section 230, again, that parade of horribles, the things I've read a few times now, they'd be able to take that down.
So, in fact, didn't your governor and Chairman Goldman and Representative King get into an issue over Gab, and it's some anti-Semitic platform?
I'm not familiar with it, but I'm sure you can tell me about it.
Well, we're
Really,
going to keep
don't.
our comments and questioning on the bill here at hand.
So on page 8, why do you give so much authority to the Attorney General, Ken Paxton?
Well, under this has to do with whether they're complying with the disclosure requirements, and so we tend to give those enforcement powers to the states.
So you've given it to Ken Paxton.
The
And
Attorney
then-
General's office, yes.
You gave it to Ken Paxton. And
His
then
name's not in the bill, ma'am. It gives it to the Attorney General's office.
I think we all know who the Attorney General is.
Okay?
We also know the manner in which he has used his office. In fact, I think he sued Pennsylvania, correct?
I thought.
For Trump?
Supposed to,
I think you flew to Pennsylvania for Trump,
Yeah.
didn't you?
yeah, I did,
Okay.
when I
So
wasn't in session.
on your, I'm sorry, I missed that.
I wasn't-
If it was
wasn't
a
at a
gavel,
time.
thank you.
Members, we're
When I left the state.
Okay.
maintain a civil tone here and keep our questions on the content of the bill.
Okay, you've got, on page 13, in addition to the power that you have given to Attorney General, you say a user may bring an action. And that action may either be for denial of their content being published or the perceived denial of reading somebody else's content that's been taken down. So if, let's say, President Trump is removed from a platform and his comments are no longer available, and 5,000 Trump supporters in Texas say, I'm denied my ability to see President Trump's comments, under page 13, line 16, you have now allowed them to bring a civil lawsuit in Texas to complain about it.
Possibly due to that hypothetical, but I'll remind you that Section 9 of that bill, it's on page 16, says this does not take effect until the 91st day after this session. So we're not allowing anybody to do anything about not being able to see President Trump on Twitter or on Facebook.
Until your bill passes, right?
No. Again, it would have to be something that accrues in the future. That has already occurred.
And then if you had 5,000, just 5,000 people who were upset that Trump was not allowed on somebody's private business platform, and they then filed a suit in the state of Texas, The filing fee on a civil suit, I think, is $285. Are you really suggesting that that filing fee is going to cover the incurrence of costs to our taxpayers for all the people that may try to use our court system as a method of slowing down or challenging or disturbing a private business who is not allowing speech that you like?
First, I think that anyone wanting to bring that litigation is going to act in a risk-averse way, with the calculation that should they prevail, all they get is attorney's fees. Should you lose, then you've literally washed a bunch of money, and so I don't think you're going to see a giant rush. That there's still a calculation on whether or not you want to front that cost, because you're not, becoming wealthy off of this. There's nothing other than attorney's fees and costs that could be awarded to the prevailing plaintiff. Secondly, from talking with the Attorney General's office and other, you'll find there's no expected fiscal impact, because we believe it can be done with existing resources, and that it's not expected to be that large of a cost to the state.
So the LBB has determined that despite the potential for a flood of lawsuits in the state of Texas, that there's not going to be any impact. Not just we don't know what it is, but somehow they said any impact.
Yeah, that's my understanding from a reading of the fiscal note from Senate Bill 5, which is similar to this bill from the Senate.
And as a lawyer, you've been in the courtroom.
Mm-hmm.
You've seen the bailiffs. Usually they're 2, 3, at least 2.
Okay. I'm
You've
just
seen the
one on the
clerks.
civil side. Okay.
At least 1, if not 2. You've seen the judge.
Mm-hmm.
You've seen, who else? The filing, the clerk's office downstairs.
Mm-hmm.
Do you really think, how long does a civil lawsuit take? It can take years, right?
Yes, ma'am.
And that means repeated visits in court, maybe even once a month. Are you really suggesting that the $285 filing fee is going to pay all those costs for an ongoing piece of litigation that could be flooded by thousands of people who believe that their personal ability to see Trump on a private company is really worth the interest of the state of Texas and our budget?
Yeah, I don't think it'd be wise for them to bring that lawsuit. Again, this wouldn't take effect until 91 days after this session, and I don't think, look, I'm not here to discuss all kind of wild hypotheticals. I just don't see that being a reality. I don't think you're going to be seeing 5,000 people bring cases like that.
You're welcome. Thank you. Members, any further questions before we move to public testimony? Okay, they're seeing none.